We had looked at some other legislations to make recommendations for any proposed change. We considered Section 26 of the Dangerous Drugs Act, as well as, I believe it was Section 16 of the Road Traffic Act. So I don't know if, just to take you through it, as it is worded in Section 26 of the Dangerous Drugs Act, it says, in any proceedings against any person for an offense against this act, it shall not be necessary to negatize by evidence any license or authority or other matter of exception or defense, and the burden of proving any such matter shall lie on the person seeking to avail himself thereof. Section 16 of the Road Traffic Act states that a person shall not drive a motor vehicle on a road unless he is the holder of a license for the purpose, and a person shall not employ any person to drive a motor vehicle on a road unless the person so employed is the holder of such a driver's license. If any person acts in contravention of the provisions of this subsection, he shall be guilty of an offense and shall be liable on summary conviction before a resident magistrate to a fine not exceeding $10,000. And the burden of proving that such person holds such a driver's license shall be upon the person charged. So I think utilizing the wording, a wording similar to both these legislations would rectify the issue that we're seeing in the current bill, because the prosecution would not have the burden to show that the person does not have the authorization.
Legal reform, any comments? Or just proceed?
Yes, good morning, good afternoon, sorry, Chair and members. Just to say that the chambers, the Attorney General's chambers has just sent a legal opinion to the Ministry of National Security regarding reverse burden of proof. We were asked to provide some legal advice. The reason it has not been shared with the committee yet is because we were requesting additional instructions, because we were not clear whether the reverse burden was only going to be applicable to the provision now on the screen, or if it was going to be a wider application. And we needed some additional instructions. Just to say that I would caution the committee about just using existing legislation and copying existing legislation, because nowadays we have to be very careful about precedents that we use that have not been tested before the court. So I would ask if the committee would just give us a little time to be able to work through this issue and work it through with the Ministry of National Security, because we have now sent an opinion to them. So the ministry will need to then go through and we will have to liaise with them about the additional instructions.
No problem, history. We look out for that opinion.
Yeah, the opinion has been prepared by Ms. Shelley-Ann Thompson, who is also in this meeting and a representative of the chambers.
102, obstruction.
Pardon me, excuse me, through your chair, just a reminder of the speakers to identify themselves. The persons who are in the boardroom also being reminded by PBCJ that persons need to turn their cameras on. Thank you.
Committee member Xavier Main. Proceed. 102, obstruction. A person who assaults, obstructs, hinders, or resists, or uses any threatening language to an authorized officer executing any function under this act commits an offense and shall be liable on summary conviction, therefore, before a parish court to a fine not exceeding $1 million or on default of payment of that fine to imprisonment for a term not exceeding 12 months.
Support in the comments. I saw your hand.
I'm sorry, I missed. Good afternoon, Chairman. Afternoon. I'm sorry, I was experiencing some
Internet.
technical challenges. I keep getting bounced off, but I know it's the stability of the internet. I didn't hear what preceded clause 102.
Well, they have agreed that the SG will have to give an opinion on the reverse burden act program to the ministry and await some further instruction, and they have agreed to give them time to discuss that.
Proceed.
Explain your legal terms on this stuff.
Yes.
Thank you.
All right.
We now move to 106, dealing with the regulations. 106.
I'm sorry, Chair. This is Marlene Aldred from the Attorney General's Chambers. Just wanted to clarify because there are some words in square brackets in clause 102. So I just wanted to make sure that the committee had agreed.
Yeah, there's a square bracket there and shall be liable, etc. You agreed? Editorial assaults was spelled incorrectly. Let's get it right. Go ahead.
Yes.
Go ahead, man.
Yes. You can.
Any questions, objections?
So we move to section 106, dealing with the
So
regulations.
just before we move on, Chairman, so you're creating an offense for the use of threatening language. You're creating an offense for statutory offense for assaulting.
Yes. It is here.
So you assault an authorized officer. Assaulting someone is always an offense, both a crime and a tort. Obstruct, hinder, resist, or uses any threatening language to an authorized officer executing any function under the Act. And this provision was deemed necessary for what purpose?
So this was to provide for some level of protection to authorized officers who are conducting their duties. So the police officers will be protected pursuant to their own legislation under Constable Force Act, but there will be no protection for the authorized officers defined under this legislation.
Next change is section 106, dealing with regulations. 106(1)(c). The form of the receipt to be given to a firearm authorization holder who makes an arrangement for storage under section 79. D, the development of a service standards framework for the authority in the determination of applications for firearm authorizations, including the appropriate administrative sanctions for failure to adhere to the standards. Proceeding, section 109, dealing with services of notices.
Sorry, Minister. In respect of the receipt, is there a reason why you would put that in the regulations as opposed to prescribing it in the schedule to the Act? it's a form. So what I gather is that it would be, so it's saying that the minister may make regulations for the form of the receipt to be given to a firearm authorization holder. Is that a matter that would be more appropriately provided for in the schedule? And so the form of the receipt becomes what is in the schedule to the act as opposed to in the regs?
That's certainly what CPC Minister. Third Minister, this is Rohan Richards. I'm thinking that the CPC may be best placed to answer this question. CPC?
CPC will tell you that you'll need instructions, but yeah, let me hear what the answer.
I'm sorry, I didn't hear the question.
Question is C. 106C, should it be better placed in the schedule rather than the regulations?
For it to be placed in the schedule, you would have to have it ready now to be included in this list of amendments. I gather it might not be ready now, so for convenience, it would be better to be put in the regulations. Plus, it's an administrative detail, which normally that sort of thing would go in regulation.
Is there a current form of receipt that is used by the FLA?
No, there isn't, Minister.
And has thought been given to what a standard form receipt would look like?
Not yet, Minister.
This is the call for the schedule.
All right. Proceeding. Sir,
We agreed that it will go to the
So
schedule.
this is, no, I'm just asking, this is the receipt that you would give where a firearm is handed over for temporary storage. Firearm or ammunition. All right, since that part of the work is not yet done, I won't delay the deliberations.
Sorry to you. When they hand over to the FLA.
When they hand over firearms to the FLA.
The receipt.
Right.
The form of
No,
the
it
receipt.
references section 70. That provision references section clause 79, and that deals with the handing over of firearm for temporary storage.
Yeah. It should be a standard form, but you know.
There's a standard form for the FLA. There one for the police. There's none no, Minister, for the police, for the police officers. But there's one standard form that's if your firearm is handed over to the authority. And my recollection of discussion was that there should be a prescribed form for all firearms handed over, whether to the police or to the authority.
Yeah.
Yes, but you did say that what it would look like has not been, the work for that has not yet been done.
That is correct, Minister.
Bear in mind that it will be necessary to have it in place when the law comes into operation.
proceeding to section 109, services of notices. And down at C, we're inserting firearm shooting range license. first schedule. Under 1, we include sale or trafficking of children.
The CP just went through the name what this specific section refers to. Also,
Continuing on the 3, any changes to an offense under the following sections of the Dangerous Drugs Act.
I'm sorry.
Import and
Just clarify.
import and export of raw opium and cocoa leaves. Yes. Oh. I understand that CPC.
Right. I just wanted to clarify that all of these insertions are just to describe the provisions that were previously included and referenced in the bill. So that's all these changes are doing. It's not really anything new.
So treat them as read or go through? Yeah. All right. We don't have it. An offense under any of the following sections of the Dangerous Drugs Act: import and export of raw opium and cocoa leaves. B. 5, cultivation of opium or cocoa leaves. 6, export or import of prepared opium. 7, manufacture, selling, using, etc. of prepared opium. 7A, export or import of ganja. 7B, cultivation, selling or dealing in or transporting ganja. Or 8, cultivating, selling or dealing in or transporting cocaine, etc. 4, an offense under any of the following sections of the Larceny Act. A, 5, dealing with simple larceny. B, section 6, dealing with larceny of cattle. C, 7, killing animals with intent to steal. Section 13, predial larceny. Section 17, larceny of postal articles. 18, larceny in dwelling houses. 19, larceny from the person. 20, larceny from ships, docks, etc. 38, sacrilege. 39, burglary. 40, housebreaking and committing felony. 41, housebreaking with intent to commit felony. 42, 2, being found by night with certain implements of housebreaking. 42, 3, being found by night, disguised, etc., with intent to commit a felony. Or 42, 4, being found by night in any building with intent to commit a felony. 5, an offense under any of the following sections of the Law Reform Fraudulent Transactions Special Provisions Act. Section 3, dealing with obtaining property by false pretense, etc. 5, using premises for commission of offense. 7, threatening or intimidating persons involved in criminal investigation or trial of an offense. 8, offenses relating to theft, forgery, etc. of access device. 10, making, repairing, buying, etc. thing for copying data from an access device or forging or falsifying access device. 11, obtaining a benefit by menace. Or 12, conspiring, etc. 6, an offense under any of the following sections of the Malicious Injuries to Properties Act. 2, setting fire to a church, etc. Setting fire to a dwelling house or person therein. 4, setting fire to house, outhouse, etc. 5, setting fire to building belonging to railway, port, or
Mr.
harbor.
Chairman.
Yes.
Mr. Chairman, can I just inquire the use of the etc. What does that mean? Setting fire to church, etc. What is it that we are to understand, etc. to mean in that setting? Or is it that there are other things that are listed under section 2 in the malicious injuries to property?
Yes. Yes.
Is it that there are other descriptions given in the Malicious Injuries to Properties Act, and we just did not want to write it out completely, or what is
Yes,
that?
no, that's normally how the marginal note is probably written.
Okay. All right. And yeah, that's a marginal note in the Malicious Injuries to Property Act.
That's correct, member.
E, picking up at 6E, friends. 6, setting fire to building of public character. 7, setting fire to thing in or under building. 8, setting fire to other building. 9, attempting to set fire to building or to thing in or against building. 10, destroying or damaging house or person therein by explosion of gunpowder. 11, attempting to destroy building by explosion of gunpowder. 12, demolishing of building by rioters. 13, injury to buildings by rioters. 15, injuries to manufacturers, etc. 16, injuries to machinery, etc. 26, injuries to bridges, etc. 27, placing wood on railway to obstruct engines, etc. 28, obstructing carriage on railway, etc. 29, destroying electric telegraph, etc. Or 36, placing gunpowder near ship with intent to damage, etc. 7, an offense under any of the following sections of the Offenses Against the Person Act. Section 22, unlawful wounding. 23, attempting to choke, etc., in order to commit indictable offense. 24, administering drug with intent to commit indictable offense. 31, placing wood on railway, etc., with intent to endanger safety of passengers. 36, assault with intent to commit felony or on constable, etc. 43, common and aggravated assault, or 69, child stealing. Move down to 9, an offense under any of the following sections of the Sexual Offences Act. 3, rape. 4, grievous sexual assault. 5, marital rape. 13, indecent assault. 15, abduction of child under 16. 17, forcible abduction. 19A, procuring sexual intercourse, etc., by threats or intimidation. 20, abduction of child with intent to have sexual intercourse. Or 21, unlawful detention with intent to have sexual intercourse. 10, an offense under Section 7, participation in activity of terrorist group. 8, facilitating terrorist activity. 9, commission of offense for terrorist group. 10, instructing commission of offense for terrorist group. Or 11, instructing to carry out terrorist activity of the Terrorism Prevention Act. 11, an offense under Section 4, trafficking in person. Or 15, threatening, obstructing, etc. Constable of the Trafficking in Person Prevention, Suppression, and Punishment Act. We proceed to third schedule. Of Section 2 of section 1, dealing with the constitution of the board. I'll just read the entire. The membership of the board shall not include any person who is involved in or otherwise associated with any relevant licensee as defined, license as defined in section 76, such that the involvement or association could reasonably be expected to create a conflict of interest or a perception that there is a conflict of interest. Section 2, disqualification from membership of board. 2C, and we are including in C, a firearm shooting range, a firearm dealership, a facility providing training in firearms, a gunsmith business, private security organization, or any other business in connection with which a firearm authorization is granted or required, a firearm broker's license, a firearm manufacturer's license, a firearm dealer's license, a firearm user's business license, a gunsmith's license, a gun club license, a firearm trainer's license, or a firearm range operator's license. We go down to section 12 dealing with
Sorry, before you move on, Chairman, those provisions are alternatives, so the committee is being invited to choose between the two alternatives. The first one is broader language. The second one specifically details types of license, which would, if the person is a holder of, would create a conflict of interest.
All right. So we agree. So we have instructed that the subparagraph be amended to include any license which is operated for the purposes of doing a business. So we have specifically asked for these to be included. So I think this square brackets to remove based on the discussions at the committee.
Proceeding now to section 12 dealing with revocation of appointments, and we are
Sorry,
deleting.
which square brackets? Because the two provisions are alternatives. So am I deleting the word occurring in the first set of square brackets and keeping the specifications in the second set?
So this is CTD Rohan, which is again CPC. Sorry, my apologies. So I think we in discussions would accepted the first set of the words in the first set of square brackets.
All right, thank you.
That's fine. Right.
Sorry.
Yeah, 12.2 is deleted. Revocation of appointment.
Okay.
One moment. Yes. 13.4 proceedings of the board. We are also deleting subsection paragraph 4. Yes. Yes, there's a deletion in the 4th schedule. If we go down to paragraph 2, I think. Yes, so we are deleting Office of the Firearm Licensing Authority, and we insert place. So it will read, and any other place as may be designated by the minister for the purpose of this paragraph by notice published in the Gazette. Yes, the fifth schedule, first paragraph, Constitution of Review Panel. After B, we are including the word and. And we go down now to disqualification on the 2 from membership of fire. And we include at C, a firearm shooting range, a firearm dealership, a facility provided training in firearms, a gunsmith business, a private security organization, or any other business in connection with which a firearm authorization is granted or required, a firearm broker's license, a firearm manufacturer's license, a firearm dealer's license, a firearm user's business license, a gunsmith license, a gun club license, a firearm trainer's license, or a firearm range operator's license, while deleting the words, the conduct of their business.
So CPC, we will accept similarly to the provision in the third schedule.
Yes.
The first formulation. We remove the words in square brackets.
Proceeding to paragraph 8, remuneration of members.
Oh. Broken license all the way. So, all right. See them.
Paragraph 8, remuneration of members. We are inserting by way of salary, honorarium, or otherwise as the minister with responsibility for finance continue may determine.
Finance will be enough. Yeah. So you know what that? National security.
Or minister would normally go to the Ministry of Finance. So even though they might relate to the minister, the approval was left to come from the minister.
So let's take a surplus here. We are not to run ourselves. So this says.
Proceeding. Yes. 10, paragraph, revocation of appointment. And down at D.
Get them done, we have to go to the Ministry of Finance.
So most bodies corporate, there still has to be
Officers. Finance, you know. Just go to finance.
I mean, I think LRD could probably come in here, but I think my understanding is the normal course of things is what's
Yeah, the location of our.
Revocation of appointment, we're deleting number 1, as highlighted there. And then we proceed down to D, delete the word authority. And
sorry, just a second. Let me look in here. Good afternoon. Number 1, you said as highlighted.
we're deleting the word,
Deleting
the number 1.
Oh.
Deleting number 1.
Oh, that's going to go the whole thing. Okay.
Because paragraph 2 is deleted, Ms. Wilkins, there'll be no need for paragraph 1.
Okay, thanks for that, TPD.
And further down to D, delete the word authority and include add review panel. Paragraph 2 is deleted. Paragraph 14 dealing with proceedings of the review panel. And number 4 here is deleted. That deals with it. Chief Executive Officer shall attend the meetings of the review panel, but is not entitled to vote on any decision of the panel. That is deleted. We proceed to the 6th schedule.
Before you go to the 6th schedule, I had a note at 12. Gazetting of membership. Did you put in a change here? I don't remember seeing here. You say at 12. There were some words missing.
Paragraph 12 of the 5th schedule, Ms. Wilkins.
Gazetting of membership.
Yes, so the names of all members as first constituted and every change therein shall be published in the Gazette.
What did we, I don't remember. Okay, it's not highlighted. And I think we kind of ran over it. All right, no problem. That should have been highlighted because that's an amendment.
Okay, moving on.
Yes.
6th schedule.
Yes. So we proceed to the 6th schedule. And we're down to 33.2, trafficking in firearms or ammunition. And we move across, we're deleting the words, shall be sentenced to. 33.3, possession with intent to traffic in firearm or ammunition. And we're deleting, shall be sentenced to. 34, importing a firearm that does not bear the required mark. Across, we will delete number 1. And further down, we include the words, on default of payment of that fine.
So if I may, Minister, so this is Rohan Richards. I think that my recollection of the discussion from the Joint Select Committee was that this penalty be removed and that the firearms so important be confiscated and destroyed. So I think we'll probably have to issue instructions accordingly.
And number 2 is deleted. On conviction before a circuit court, a fine or imprisonment for a term not exceeding 10 years. All of that is deleted.
I'm sorry. Sorry to stop you, but what was the decision concerning 1? I didn't get that. I know there was a discussion with the MNS team, but I didn't hear what was decided.
Right. I was saying, Nadine, that my recollection was that the committee was minded not for there to be a penalty of a term of imprisonment or fine, but rather for the firearm to be confiscated and destroyed. 34.
Right, that is consistent with my notes as well, CTV, and I also went further and wrote where it was agreed, I thought, that a sanction would not be imposed. So if what we have is an amendment of 1, which would still be a sanction being imposed.
What is that against? This is a firearm. A licensed importer bringing a firearm without a mark. But the firearm with the was maybe they're not criminalized.
Yeah. So the idea was, well, my recollection was that firearms would be confiscated.
Yes.
Yeah, this study was that the person has the permit to bring the firearm, and they bring a firearm, the dealer. They bring a firearm that is unmarked, properly marked. He would have bought it from somebody. He could even bought it illegally or bought it from somebody who was not an appropriate dealer. But he had permission, therefore the challenge was to criminalize that, but to see the firearm.
If I remember correctly, Minister, I think the issue was that we would be imposing a sanction on the person who was not responsible for the infraction, because they're at the receiving end. I think that's
to see the firearm.
Right. So I think that Nadine, if I remember correctly, the idea was that the firearm and the ammunition would have been confiscated.
Yes.
But the sanction would not apply to the person.
Yeah, that's correct.
Under 3401.
That's correct. So,
right. So that's why I said that we would have.
I don't think that should be on in the schedule at all.
Right. So that's what I'm saying. So we'll have to issue instructions to the CPC accordingly.
I mean this. Yeah, so you'll come back.
Yes, got you.
Proceeding on to 36.2. And we're substituting. You see a fine not exceeding, we delete the word 3 and we insert 2. So it would now read, on summary conviction before a parish court, a fine not exceeding $2 million or imprisonment for a term not exceeding 2 years, sorry. So 3 is deleted again, and we insert the word 2. 38.2, manufacture of firearm or ammunition other than under and in accordance with firearm manufacturer's license. Delete the word shall be sentenced to.
I think the 2 should remain. Are you sure the 2 needs to come on? I mean, you cannot.
Yes.
Yeah,
no, I think it's fine. On conviction before a circuit court, imprisonment for life. On some conviction before a parish court, a fine was exceeding $2 million.
Yeah. Language. Yes. Testing without authorization.
39.2, testing, etc. without authorization. Cross, we delete the word such. Insert a. Term, we delete the words of not less than. And insert not exceeding 5 years, and delete as the court considers appropriate. So it will read, on summary conviction before a parish court, imprisonment for a term not exceeding 5 years. And 2, we delete the words shall be sentenced to imprisonment for life or for such other term of not less than, delete the word 7 and insert 15.
Mr. Chairman, I need to just, I'm seeking some clarification. In respect to 38.2, where it has on conviction before a circuit court, that's on the earlier page.
Yes.
Imprisonment for life. That is in respect to someone who is found guilty of manufacturing firearm. And in respect to 39, on convict, there is a minimum period in the circuit court of not less than 15 years. So although it says imprisonment for life or for such other term of not less than 15 years.
If I may remember, I think this, sorry, this is Rohan Richards again. I think that,
Yes, Mr.
that might be an error. I think our instruction should have been replacing not less than 7 years to not exceeding 15 years. So it really should have been not exceeding 15 years for 39.2. 39.2.2, right?
Okay. All right. Thank you.
Not exceeding. So,
I'm so sorry. This is Marlene Aldred. So sorry, I'm not clear then. So 39.2, you would not have imprisonment for life for the circuit court?
Right, right. So it's not exceeding 15 years.
So conviction for a circuit court.
Okay, thank you.
All right, proceeding 42, illicit dealing. On conviction before a circuit court, we delete the word shall be sentenced to imprisonment for life, and we delete the words thereafter.
All the way down there.
All the way down.
Yeah.
45.
Independent contractor. Oh.
Yes, 40 subsection 5, allowing premises, etc., to be used for trafficking, etc. On conviction on indictment before a circuit court, you delete the words of fine or imprisonment, insert for life, and delete thereafter. And that's at the word parole there would stop. 47.7. Oh.
43.2. 43.
43.2. Sale, testing, modification, or proofing of firearm or ammunition contrary to the requirements for the holders of gunsmith's license. Insert the number 1 on summary conviction before a parish court imprisonment for a term. Delete the words of not less than and insert not exceeding 5 years. And we insert number 2, on conviction before a circuit court, imprisonment for a term, delete the word of not less, delete the word less than 15 and insert exceeding 7 years. So it would read, on conviction before a circuit court, imprisonment for a term not exceeding 7 years. 45.2, unauthorized possession of firearm or ammunition. On summary conviction before a parish court, delete the word such, a fine, delete the word of, not, delete the words less than 3, and insert exceeding $5 million or imprisonment for, delete the word such term of, and insert a term not, delete the words less than 3, and therefore inserting exceeding 5 years and delete as the court considers appropriate. So the clause would now read, on summary conviction before a parish court, a fine not exceeding $5 million or imprisonment for a term not exceeding 5 years. 2, on conviction before a circuit court, delete the words shall be sentenced to. So on conviction before a circuit court, imprisonment for life. (47) 2, carrying firearm or ammunition in a public place without authorization. Here we delete the word the word 5, substitute it for 3. So it would read conviction, on summary conviction for a parish court, a fine not exceeding $3 million or imprisonment for a term not exceeding 3 years. 48, 2, requirement applicable to person authorized to carry firearm in public place. On summary conviction before a parish court, a fine not exceeding, and you delete 5 and you insert the word 3. So it would be $3 million or imprisonment for a term not exceeding 3 years. 49, 2, carrying firearm or ammunition in a restricted area without authorization. Again, we substitute wherever the word 3 appears, we substitute for 5. So it will read, on summary conviction before a parish court, a fine not exceeding $5 million or imprisonment for a term not exceeding 5 years. 53, 2, failure to report lost or stolen firearm or ammunition. And it will read, on summary conviction before a parish court, a fine not exceeding, delete the word 1, insert the word 5. So it reads $5 million, and you delete the word or imprisonment for a term not exceeding 1 year. (75) 2, we delete the letter A and B, and we also insert the number 2, and 2 would now read, on conviction before a circuit court, a fine or imprisonment for a term not exceeding 10 years. (92) Failure to comply with a request by a constable to stop and search a conveyance or intimidating or preventing the driver of a conveyance from stopping at the request of a constable or escaping or attempting to escape from a conveyance requested to be stopped by a constable. And here, on summary conviction before a parish court, a fine not exceeding, we delete the word 2, and wherever that so happens, we insert the word 5. So it would now read, a fine not exceeding $5 million or imprisonment for a term not exceeding 5 years. 93, failure to produce firearm authorization, and we delete the word 2 and insert the word 4. 104 becomes 105. the 7th schedule, section 117. So, the gun court act. Move down to section.
Reintroduce the gun court, Minister of Justice. Let's reintroduce another red.
Yes.
And lock them up in there for life.
Page 142, dealing with the Gun Court Act, and down to paragraph B. On the firearm offense means A, an offense under Part 2 or the 6th schedule of the Firearms Prohibition, Restriction, and Regulation Act, and we insert now other than an offense under section 1054 of that act.
Mr. Chairman, sorry, can I just have a look back on the 93?
90.
93.
93. 90
Yes,
subsection 3.
Yeah, it's
93.3.
no man, 93. Failure to produce.
Yes.
A long debate on this.
All right. I am in looking at it, if you recall, we had a discussion, right?
Yeah, didn't we amend this more dramatically?
We had a discussion regarding 93, section 93.
92, 93.3.
93 about producing the actual section
Right.
itself.
Right.
Right. And if you fail to produce, but then we had amended to put in 4A, which says that if you are unable to produce, that you have 24 hours. If you can satisfy the officer. Correct?
Yes, that was discussed. This is the identity and address.
Yes, yes. But if I think I'm not appreciating the situation. Suppose an officer stops you and says, "Seize you the firearm, can I see the license?" And the person does not have it. He has failed to produce. So a person who fails to comply in accordance with subsection 1 or 2 commits an offense. That's what 93.3 says. So the police officer, the person pulls out his driver's license and his NITS card and his passport and so forth and presents it to the officer. The officer says, "Okay, I will still give you the 24 hours." He will say it, but you have failed to produce it to me, so I am going to still charge you because he has committed an offense.
Hi, member. This is Alana One List from the FLA.
But he fails to produce it, he has committed an offense.
So if you look back at section 93.4A, it says the constable or authorized officer shall permit the person to produce a firearm authorization within 24 hours thereafter at such police station as may be specified by the person at the time when the firearm authorization was required to be produced under subsection 1. And then you go further to B, where it says if the firearm authorization is produced pursuant to paragraph A, that person shall not be convicted of an offense under subsection 3.
Okay.
So, right. So where there has been a failure to produce, once the 24-hour grace period is provided and the person in that grace period complies, then he will not be held liable pursuant to
No, he will
paragraph
he will
B.
not be convicted.
The weapon is supposed to be detained during that time.
Pardon?
He will not be convicted.
No, you're not the convict.
Well, it should not be right. The person shall not be convicted of an offense under subsection 3.
You should be charged.
If you're not going to be held convicted, there shouldn't be any
Can be
charge.
charged, bro. He can be charged.
No, shouldn't be charged.
But then for what? If you're charged.
I understand the question. It should be charged unless you pay to produce.
Right. Right. I think I see the issue, but the intention should be not to charge, not to prosecute in any way since you'll be in compliance. Because if you're convicted, if you're not convicted, then what would be the point in charging?
The clear to say that.
Yes, maybe we can
Should not be
gain some
charged.
clarity in the construction of the provision.
Like if it's this evening, I need all those days I have not for you.
We'll proceed. We are at Gunpowder and Explosive Act. And we go down to paragraph 3. In section 13, delete all the words appearing after the words may be forfeited, and we insert now and the person guilty of such breach. And substitute therefore the words commit an offense and is liable on conviction before a parish court. 2, and we are inserting the word fine not exceeding $1 million to or to imprisonment for a term not exceeding 1 year.
Get right, procedure.
Moving on to page 146, inserting Proceeds of Crime Act. In the second schedule, delete item 4 and substitute therefore the following: prohibited weapons, etc. 4, an offense under part 2 of the Firearms Prohibition, Restriction, and Regulation Act. Public Order, the Public Order Act under 1A1, we substitute the word years for $1 million, so it will read a parish court to a fine not exceeding $5 million or to imprisonment for a term not exceeding 5 years. Move further down to the memorandum of objects and reason. And it's just to correct the year from 1976 to read 1967. So that's it. I'm told that JCF wants to intervene in respect of section. JCF wants to make an intervention in respect of the provision dealing with controlled delivery. That section. Yes, section 98. JCF.
Hello, can you hear me now?
Yes.
Yes, I had to switch devices because it appears as if you weren't hearing me before. Shanique Crooks Alcott, JCF. We wanted to revisit clause 98. B specifically, which focuses on controlled.
B. B. Control delivery.
Yes.
Yeah. Okay. What's the request? Great.
You may proceed.
Okay, great. Clause 98, we were proposing that it be broadened to include clean control delivery. I note that this was a recommendation initially made by the JDF. However, we do support the recommendation. What it is that we want to do is to broaden the relevant section to capture clean control delivery. So those are circumstances where perhaps Intel provides us with some information and the law enforcement officials are able to intercept delivery and replace the items of that delivery, for example, illicit firearms with dummy firearms, so as to capture the intended person at the intended destination. We have looked at several jurisdictions, particularly in India, how they have worded their section. And what it is that they have done is they have included within the section substances, which would, as it relates to drugs in that instance, is substances substituted for them. So what we're proposing is illicit items that may be substituted. So I guess that would be for CPC to see how they could reword the section, but the recommendation is really to capture those circumstances where we may be able to intercept and replace the firearms with dummy items.
If I may, Minister. All right, Shani, we hear you. We did get the proposal from JCF. So we're working on the drafting instruction to send to CPC, which we'll do so momentarily.
Very well, thank you.
Hello, Chairman.
Go ahead.
Just a bit of clarification with that provision by the JCF. What is the intent behind that provision? Is it to provide the lethal contraband to be in the hands of the person? Because I was thinking that
to replace them, replace the lethal weapons.
Yes, correct. So to lessen the risk, to ensure that illicit firearms do not reach into the wrong hands.
Then if in a transition it slip through the cracks, they get a bogus stick.
Okay. So those substitutes would have some sort of discrete markings or so to be identified as the substitute?
I would believe so.
Okay. I just want to get a sense of it from an operational standpoint.
Yeah,
Okay, thanks.
the time usage will determine, but they'll have to, something that they can track and identify. So track on it and when it's the truth is not legal. Yes, we have gone through to the end. All right, if anything you wanted for this evening, Mr. Richard. All right, so what I need to look at then, I need from.
Sorry, Chair, I have my hand up. Marlene.
Oh, yes. SG, go ahead,
Thank you. I just wanted to ask, as it relates to that same issue, is it that the provision will only allow for the controlled delivery when the items are substituted? Or are you saying you would also allow the procedure to occur with illicit items? So I wasn't clear on how you're going to do the amendment, whether it's only going to operate when you do a substitution. I'm not clear.
The substitution should be done. That's what the law is proposing. The wording may need to be made clear because you can't.
So you're saying then that it could never occur with you allowing the actual illicit item to go through. It must be substituted. I'm just saying you're changing what's here. So I just wanted to be very clear on what you're saying.
Just to be clear, SG. So I think the extent of what is being proposed by the JSF and the JDF, and also in discussions with the ODPP, is that we expand the provision. So not only to also allow the legal items to go through, but also to be able to exchange the legal items with dummy items. So it will be both. So it's expanding the provision. Right.
The better option is
correct, Mr. Richards. That's our position. So it would be both.
In other words,
live control delivery as well as clean control delivery.
If the time allowed, the best approach would be to substitute with non-lethal weapons. But if you cannot do it, it's allowed to go through and ensure you capture the person.
Right. And there's precedent operational in respect of one particular case.
So let me talk to the team about our timing. As I said, I've taken some time from my colleagues on the basis that this bill.
Sorry, Mr. Chairman. Mr. Chairman, before you move on, because that seems to be that you're almost good wrapping up a bit. I just want to inquire, probably this is more to Mr. Richards. I don't know if CEO from FLA is also here, but query. A query. If an unlicensed person goes to an approved firearm, FLA approved range for the purpose of being introduced to firearms and be in the process handle a firearm, shooting at a target, etc., to establish competence or for some training in order to determine for themselves whether they want to make an application for a permit. Is that person handling a firearm illegally, or do we have to make any provision for them?
Unless they are going through or with or under the instructions of a trainer,
yes,
they would be contravening the legislation. Yes,
right. But this legislation that we are putting forward provides for that situation.
Provides for.
All right. So a person goes to the approved range. You have a trainer who is there who has his permit. Does it cover an individual who goes here for the purpose of the training?
No, because they should get approval from the FLA in order to train.
No, but if the person goes to the firearm range, you want to see if he's allowed by the trainer to fire some rounds to get a feel if you want to use it or not.
No, but in order to do that, he would have to get the approval of the FLA to be able to do that. Otherwise, he would be contributing to the legislation.
There's a genuine concern in target shooting and skeet shooting. For person have to be oriented. But there are not many trainers, not many people that are licensed, only about 2 or 3 people.
Right. So it's a simple thing in my mind, Minister, is that they can apply to the FLA to get the trainer's license. And the person who wants to be trained can apply.
If you don't want to give a 3 trainers license, fire.
Maybe it's an opportunity for FLA to expand the available.
No, I think you might have to give the license firearm holder some leverage.
So, Minister, I'm going to caution us again. And I'm Minister, I'm still going to caution us, and I'm very, very uneasy with that kind of approach, because what we don't want is, I don't want to.
But you'd have to give them some more. If only 3 trainers in the island, no. The identification of trade, the meaning of trainers have to be redefined.
That's
every rate you operate should be a trainer.
Right. We have to discuss that with the FLA. I wouldn't want us to.
FLA sponsor. I told on the 3 trainers in the island. First shooting. See, nobody will to shoot. The train. SG coming in and then the Dobson.
No, sorry, I'm on a different point, so I would allow the discussion.
I want to pick up on Senator Sinclair's point, which, if I think I appreciate where Senator is going, I fully support that point, which is what I understand Senator Sinclair to be saying. Someone who is a legal licensed firearm holder, say their spouse, they want to consider to have a firearm, male or female, whichever one. And before going through the process to say, yes, I'm going to get one, by making the applications, etc., they want to be able to expose themselves to the firearm and its use, and indeed in a controlled environment, such as on a licensed range with a licensed trainer. Why would we want to prohibit that?
May I just ask a question before you, just to put this into context. I, as a license, as a person with a driver's license, cannot take somebody out on the road to use my motor vehicle without a learner's permit. So it's the same kind of context that we need to be operating under. And I don't
think, Mr. Richards, when the person driving the car in their private property, we don't prohibit it. When they go out on the road with others, yes, they have to be licensed. But on a range, on a shooting range.
A range is still a public place?
I'm going a little further. The person who applies for a permit gets an approval from the FLA, and they go to the range. They would not have been exposed to a firearm in their life before. They are not any different than the person who goes to the range with a trainer, a trained trainer, certified trainer. They're going to treat them the same way, totally new to the firearm. Why is it that that person, the lady's husband or the husband's wife, cannot have that exposure in that controlled and regulated environment with a trained personnel?
Because I think what is going to be happening is we're opening the door for persons who may have nefarious intent to go and start to practice and to get better target shooting. And I think that this is something that is, for me, that we ought to think a little more carefully about. And I would not personally, and from a technical perspective, want us to have that approach where we give this free for all for anybody to be able to start to train persons to do target practicing. To start to train without the requisite license or permit from the authority. Because to get a permit, a user's or what special permit, there are certain things that the FLA does to see whether or not you're fit and proper to be able to handle the weapon. I think that we're running down a very slippery slope if we start to.
The challenging is
I was thinking that those with nefarious intention, like the criminals out
I think
the range.
Member Jackson, Senator Charles, I think where the real challenge is, from my understanding, is in sport shooting. And I still, shotguns are still not a major challenge in the criminal around the world. And I understand that there are not many trainers in that. A lot of the people who practice, so they're licensed. The young one, they're licensed father or friend. And you don't want to criminalize that activity. I think that I'm going to stop it. Because a man who training his son to use shotguns and kind of train up.
It will be kind of difficult to carve out an exception for this kind of thing.
An individual, the license to operate to use a shotgun can provide.
Then it would be of general application. And once again, I'm going to advise.
I think on his first shooting, you have shotgun there.
So I'm not convinced that within the framework that we have, that persons who want to do that can't apply for a trainer's license. And the individual license.
I will give them something. Oh, sorry, they're competent. A trainer license is a specific thing, which is a business.
What the rate is that the authority is going to call it, but it has to be done within the framework of the regulation, of the regulatory entity.
When a man applying for a shotgun license, he asks for competence assurance or something. You put something and say he gets a competency permit or something, which allows him to instruct or provide guidance to his immediate family and friends, whatever it is. Can't be done in there. The sport shooting is where the conflict is. Where there is no really big issue. I mean, very few gunmen carry a shotgun, them think it's a waste of time. No, but they want practice with a shotgun. Look at it. Right? Let me look at that to this. All right. Any other comments on the general bill, laws, amendments?
So, Mr. Chairman, before, so that is something I take it that as a policymaker, you will take into account, and the technical persons can look at it as to how to.
Yeah, especially as it relates, if not even generally, at least to sport shooting.
Yes.
And I support that.
Within the restricted era. And I was just wanting to find out from Mr. Richard, because Member Jackson gave an analogy of the person driving on private property and not on the road. And you said that the firearm, the license range is considered a public place. That is actually state. If I could be shown, because I checked the interpretation section, there's no definition of public place, but it may be contained in the section that deals with firearm range or license range, I don't know. Is it there to say that that is a public place as against
Interpretation Act.
Yeah. Pardon me?
It's the definition in the Interpretation Act would apply.
That yes, and does that definition include a firearm range, or because can somebody be excluded from a range, a license range? Can the operator exclude someone?
Should be able to do this is private range.
So I don't know if a firearm range approved by the FLA would fall within the definition of a public place under the Interpretation Act.
Yes, you should not take a range. It pays what more than a range. That's some period we shoot. Is the range? The ski shooting place is the range. I'll ask the technical people, Chair, Senator, to look at it carefully, because sport shooting is not usually done on ranges. Most sport shooting is done on home property.
Well, I think the provision speaks to the discharge of firearms in certain places, which seem to include even your private property. If I remember the provision that speaks to that you can just I don't know what takes place at a range. really, like that. I've seen persons training on a range, but I didn't know it excluded, or persons did not go to that type of location for whether to train in respect to sport shooting with shotguns. But there is time, because you have some other meetings, so probably it can be discussed and considered. And we don't delay it.
I don't want to carry over meetings. The sport shooting, I think the real concern is sport shooting and the involvement of sport shooting, Senator.
That is, yes. That is more, yeah. Oh. Even in that era, Mr. Chairman.
The clear shooting is because I said, while I don't want to open my door, shotgun, use our shotgun, not a particularly popular, not a criminal weapon, right? It's the largest sport shooting, bird shooting, clay shooting, etc. And if the law can seek to accommodate sport shooting, and then a lot of that is done on big open spaces. There are only 2 ranges in Jamaica for that. There are 20 other ranges.
Well, I mean, I don't know either, but you may have ranges that are in significant open spaces and not just an enclosed environment. So
that's what I'm saying, the open space. But if they want to go on a property in the middle of center and do some play shooting, it shouldn't be criminalized. That's the best place to do it.
Once you're under the supervision, the direct supervision of a licensed person.
Yeah, that's my view of a licensed, experienced shotgun operator.
Yeah.
All right, then I think I'll give a look at it in that context. Sir. I think SG was on her hand up.
Yes, thank you. Thank you, Chair. My issue is in relation to clause 89.5. At the last meeting, I had indicated that I'd had a concern and that I would review the provisions. Having reviewed the provisions, I know that they are very similar to the provisions in other laws, such as the FID Act. However, I'm concerned that we have defined Foreign Law Enforcement Agency in a very wide way. So normally the scheme in other legislation where we have this type of mechanism is, and I'll give you as an example, in the FID Act, the Foreign Law Enforcement Agency would be an FIU in another jurisdiction. So you have the FID in Jamaica relating to an FIU in another jurisdiction. Similar kind of thing for the FSC, that they would relate to a member of the Egmont Group in another jurisdiction. In this bill, Foreign Law Enforcement Agency is very wide and very vague. It's any entity that can investigate or prosecute. And that's really very wide. The second issue I have is what the provision relates to. And it just says it relates to criminal offenses. Again, if you look at any other of these laws, so again with the FID, it would relate to financial crimes. So it usually makes it very specific as to who you're going to share with and in relation to what matters. And I'm very concerned that this is so wide and very vague.
In relation to criminal offense, SG, I'd agree with you. We could maybe pin that down to firearms and ammunition.
Correct. So I would really think it should be tailored to the bill.
No, I don't know. You can narrow down the basis for the foreign law. We have to deal with what we have. Now, there are 19 agencies involved in law enforcement in Jamaica. All of them deal with firearms. And it'll be difficult to pin because ATF is one.
No, sorry, but Chair, we're talking about the Foreign Law Enforcement Agency.
I'm saying there are 19 of them operating with one of our partners, and each of them have to be given some authority because they all relate to firearms. And they're there for different reasons. The ATF is the primary, but we couldn't manage that at all. Because the Homeland Security does it, the NEL does it, the Postal Services does it, because they have that, and in fact, the Postal Service is the most critical one. How do we define it? We cannot exclude them. And then we go on to the other agencies involved. They all come back to illegal trafficking. The ATF is just a specialized agency. But we have In fact, most of the firearms we get comes out of Postal Service and Homeland Security.
But Chair, I still think there has to be some way to narrow it, because it cannot just be any entity that investigates or prosecutes criminal offenses.
No, I don't even can narrow that down, SG.
You're going to have a problem if there is an issue, because this is a rights-based issue. It can infringe rights. And part of the whole thing of, we don't know that. With respect, Chair, I cannot say that based on how this is phrased. There's nothing that says that these are relating to police, or it just says anybody who you have in other jurisdictions. Remember, we're not just talking about America. This is saying in any other territory. That's any other country in the world. And we're saying anybody.
I have prosecutor or police powers, and well, it might be you have to the police authority, because the agents that deal with criminal activity, transnational criminal activity, we are the only country that have a national police that deal with that, and we have added MOCA. The rest of them all have these spread of agencies which are not defined, can't be defined outside of this. Postal Service, how do I exclude the Postal Service? I can't. How do I put them in here?
You're going to have a problem justifying this issue, because I'm just pointing out that we don't have anything described.
How do you exclude them? I just have realistic. How do you exclude those agencies?
I think it would be for your team to go through to see, because for instance, you're identifying maybe 3 or 4. You said there are 19. I don't know what the listing is. There must be a way for your team to look at the listing. And I suspect you are looking only at one jurisdiction. And I'm saying, look back at the provision. The provision is not limited to one jurisdiction.
That one jurisdiction, they call that is law. All the
Sorry?
guns come from them. That one jurisdiction is where all the guns come from.
No, I understand, Chair, but my point is you have to also take into consideration that this will apply to other jurisdictions. And you may have, sorry?
When that happens, SG, you go to court and you defend me.
No, but I'm pointing out the difficulty from now.
It'll be difficult, but I cannot exclude anybody from the jurisdiction dealing with. And that's the only jurisdiction that have these multiple agencies. I said something, I am, from sometimes in that case, the Postal Service, and they're accustomed to their intelligence agencies, to their police activities otherwise. Right?
Well, Chair, I'm sorry, but the way how it is crafted now, I don't see how these chambers can support the provision. We cannot.
I bad, but I don't see any way I can give a policy direction to amend it to avoid it. I will have to include all of them. I can show you the list of them. About 19 persons, about 17 people. DA, ATF, what is it? Postal Service, INL, Homeland Security. Is on the whole. Yeah. The only way to describe it to come under this kind of broad heading. Nobody has had them.
Can we take what SG has directed?
So what I do is you get to look at it and look at them, but we have to be careful. I cannot allow it to build. Because that's a jurisdiction dealing with. This entire law is because of them. And in fact, their police is not here. We don't involve with the police at all. We involve with agents that cannot be described as investigative and prosecutorial. Their police force plays no role in illegal firearm trading. Neither their local or national police. If you describe the FBI as a national police, their police plays no role at all in our relationship. So it poses a particular problem. I like to apply your mind to it. That there is the issue. But I said, their police plays no role at all in firearms and firearm export. So what you have to give me is a different definition. But the definition here is the only one that SC can include the 10 or 11 people who are here assisting us in prosecuting.
Let's say narrow down the offense, and I guess we say. So narrow the offense, since criminal offenses are broad.
I agree with that. Criminal offenses was a focus on firearms and other things that may affect firearms. Homeland Security. Postal Service deal with scamming the cameras by guns. You have to keep it all together. Yeah, that's it. Come on, trafficking.
So
Trafficking, trafficking money.
So we can look at.
And the criminal offense definitely need to be timed, but I don't say we can change the other one. So SG will come back to you and be a guide and advice, but it'll bear in mind, there's no policing work with us. In other jurisdictions, yes, the police, national.
Yeah, no, but Chair, I was not saying it should be limited to police. That was not my point at all.
No, what I'm saying is, I don't know how to define them.
And can I just make the point? If you look at the end of A, it doesn't even it just talks about an entity having investigative or prosecutorial functions. And it goes on to say, and includes an association of such entities. What does that even mean? Who would be an association?
I'm saying that the police don't operate with us in this field at all. The police
I understand, and I'm asking who would be an association of these very vague entities? Because my concern is not even so much the jurisdiction that you're looking at. I am concerned about every other country out there.
Yeah. No, and with the schedule, I'm telling you, you'll have to find a way how to find these people because I just have to deal with it. I don't deal with it.
So I'm unable to help because I don't know which entities you are targeting, and I'm still saying, why do you need the words at the end of the provision and includes an association of such entities? Why is that necessary? Who are you targeting with those words? You have to know who you're targeting when you're putting this in. I mean, it's already wide, you know. It's already so wide, and then you have added these other words.
What you look for is not entity. And is talking about the United. And is an entity. Associated. So security. Investigate. It's an entity we have to look at. You have to step back. First of all, the policy SG is to be as broad as possible. Let me tell you that. Anybody involved in trading going to Jamaica who can help us must be allowed to help us. Now, how I ensure that those are infringing our rights is another issue. So I'm with you on the criminal charge involved, but the basic mood, the people are involved in gun trading and ammunition are very sophisticated. They involve a broad range of activities and need a broad range of organization to deal with them. So there is no hesitation to challenge to take the law to the boundaries, let me tell that from the government point of view. We will take it to the very boundaries because it is our clear and present danger. And everybody is Christ here. It is causing mayhem in the country. So the law must be broad enough to catch anybody and leave no loophole. And therefore the people who need to help us, anybody involved in stopping it, must be allowed to work with us. Anybody and any entity. So it has to be broad. That's where we're coming from. Now you can draw the bounds around that. But that is the policy. And you have to draw up a law to meet that policy. Any single entity, that church, organization of faith, if they help them to stop going from Jamaica, have to work with them. Right? So, you know, it's a service club.
Chair, well, already, but this doesn't convey what you're saying because this only speaks of persons who have an investigative or prosecutorial function. So it wouldn't include a church.
If they give the investigator to a church, then we'll take them too. That's all I'm saying.
Right, but I'm saying it wouldn't include a church. This says you have to have an investigative or prosecutorial function.
That church, I won't include them. So anybody in the country, anybody that the government to which you're referring to, use that authority to investigate and prosecute anybody involved in firearm, illegal firearm movement, how to be allowed to work with us. And then the institution is so geared. So within that framework, I'll give them the law to work with them, but they must be allowed to work with us. But even though they're here, ATF is here with the principal responsibility. Very few traffickers are apprehended through ATF. And it's all the associated ones involved in DA, drugs, trafficking, in scamming, and the INL, which is an entity which coordinates a number of activities, similarly as inland some agency, and Homeland Security, an institution separate from the relevant agency they supervise, but they have their own investigative and prosecuting authority. So it's a very troubling thing, but have to ensure that they all have a role to play in conjunction with the local forces. But I can't give them this freedom of choice to move around the country as they want to. So the narrowing of the criminal offenses, I agree with, but I don't. You'll have to think through how do you give me the authority to work with all the relevant agencies, which we're working with. And they say what I name all of them, which I don't think they would be appropriate for the legislation. They organize their own things. That's the only jurisdiction they're challenging them. Because there are other police agencies which you work with easily. But they're the ones we have the problem with. And narcotics. International narcotics, yeah. They work with the ATF, postal services. Secret Service not here. No. They do somebody, which is other one do. They deal with money laundering. Homeland Security. What does it have? The agency. FBI. And we work with NYPD, local police, city police. ATF. Difficult. SG, if we can find a definition that includes these various agencies, I'll have to put in there, but I can't say it otherwise. But I said the criminal offenses, I quite agree with you. But how we can exclude any of these agencies, by definition, I don't know. I have been with all of them. 1, 2, 3, 4, 5, 6, 7. There are 9 I've counted off so far. There are 19 people. I think all of them are different, but I have 9 I can recall the top of my head. Support is on you want to raise your judgmental wisdom to the table.
I've been listening, DPM. I've been listening. I appreciate the concern that has been raised and the implications of the concern. So what I will do is to work with your team behind to see how we can refashion the provision.
I said, Minister, my concern is there are a number of agents which is hard to define. They cannot shoot police arms, which we have to work with. We cannot exclude any of them. So you have to find
there is a way to deal with it, Minister. We look at it. We look at it.
But it has
it was raised at an earlier stage, you may recall, the breadth of the definition, but the concerns raised by the learned Solicitor General are concerns that have to be addressed.
I appreciate them, but I'm saying that at the start, the policy is all the relevant agencies that are involved in investigating transnational crime to Jamaica, because they all link back to firearms trading, so the people who earn their money from.
May we just skip over to the provision where the foreign law enforcement agencies used? Let's just look at that provision.
Yeah, it says foreign law enforcement agency means an entity having investigated or prosecuted.
No, it's defined there. I'm looking at where is the provision in respect of the
Starts at
foreign.
6 at the top. It starts at 6 at the top of page 86. It starts there and it continues through to 7 and 8, dealing with exchange of information and so on.
So the reason why great care has to be taken, and I think it has been articulated, when you are exchanging information, you're actually engaging the privacy right. And depending on how it is done and the purpose for which it is done, you run the risk of a constitutional claim. It is not something that we can get around, DPM, except to carefully provide for where exchange mechanisms. So it's saying, subject to the provisions of this section, the registrar may, with the approval of the minister, enter into a contract, memorandum of understanding, or other agreement or arrangement with a foreign law enforcement agency regarding the exchange of information relevant to the investigation and prosecution of any offense involving a firearm or prohibited weapon. Now, we do have experience in the jurisdiction in relation to the exchange of information, and we do have guidance from the court on this matter. So if the purpose of it is to enable the minister, to enable the registrar, subject to the approval of the minister, to enter into agreement, DPM, let us just look back on the provision and look back on the definition against the type of agencies that the corporation you would be seeking to cooperate with in respect of the investigation and prosecution of offenses. There is no getting around the deep analysis and the careful design of the provisions to meet the standard that we have in the Constitution as adjudicated on by the court. There's really no getting around that.
Regarding the exchange, irrelevant to investigation, it's not at large you could have an exchange.
No, I think the point is that you may have the provision is going to be limited. The use of it would be limited because the exchange of the information would be made pursuant to a contract or a memorandum of understanding. I don't know why you want to put a contract. So even this, because of the binding nature of a contract, an MOU operates a little differently, or other agreement or arrangement. So I would also say that this provision should be looked back at. We do have experience of how functional cooperation works and the exchange of information, how the information can be used, when and where and at what stage, whether it's used for intelligence purpose, whether it's used, well, it says for it, well, it's investigative and prosecutorial. But it is a matter that we will have to take great care with.
I'm with you, but how explaining it's already very confined. It's an investigation or prosecution. Those are matters that have gone a certain way where you can identify an individual with criminal intent as we're investigating them. You must have enough evidence to go at public investigation and prosecution. So how can I limit further the police in doing their work here?
No, DPM. The point that was raised.
I need to exchange information with the relevant authority.
All right. No, the point, as I understood it and understand it, is that you may have any of many agencies that are involved in the investigation or prosecution of criminal offense.
Right.
So take Jamaica, for example. We would not be foreign, but take Jamaica. We have a number of agencies across government where the statute creates any of many offenses: solid waste offenses, environmental offenses, planning offenses, you name them. And you may have an agency of government who is involved in investigating and prosecuting. The intention is not to have any investigation, but when it is looked at in relation to this provision and I'd have to look on the entire provision, then the exchange of the information would be contingent on having an arrangement in place. I would take out the contract, entering into a contract for the exchange of information.
Well, Minister, if you go back to A, where we were at the beginning, we're going to ensure that the investigation is confined to criminal offenses related to firearm and firearm trading. Do I agree to that? That the criminal offense is too broad, and therefore that will be settled. So you're dealing with criminal investigation to firearms trafficking, manufacturing, trading, ammunition, explosives, etc. Those will be settled. That's what we're investigating.
All right. So let's be clear. What you want is an enabling provision for cooperation between agencies, investigating agencies in Jamaica and similar types of agencies abroad for the exchange of information in order to stem the illicit trade and traffic, etc., of gun.
Sorry, it's not of agencies in Jamaica with agencies overseas. It's the registrar. It's the registrar in Jamaica with others overseas. And I would like you to turn your attention to the words at the end, includes an association of such entities. I would say to you that one interpretation of those words is that that association would not need to be an entity that investigates or prosecutes offenses.
No, the investigation, such an agreement could be had with Homeland Security, which is a whole ministry. Homeland Security is a crucial agency.
So
DPM. Government arrangement with Homeland Security will have to be covered. And if we don't put it there, we're going to get in problem. Homeland Security is the primary organization. Yeah, go ahead.
DPM, all right. So my suggestion is, first of all, I agree that as worded now, it is too wide and can be problematic. I think both the definition and what is contained here at 6 needs to be looked back at. So once we're clear about what you're seeking to do, and there is clarity in the policy, then it would be easier to recast the provisions. We'll also can look at the agencies. So you may have a certain type of agencies in a single jurisdiction in place, but the law is not a law that is going to apply only between Jamaica and that jurisdiction, because you are legislating generally. Now you can specify agencies, and then you can do similar types of agencies elsewhere, or you can provide for the description of the agency without casting it so widely. And I do agree that the end words in respect of the association may be more harmful than helpful. I don't know what is intended to be captured by that, because it's not the umbrella body that you are going to be engaging with. And I also think that you may want to take a look again at this provision.
What I'm trying to get is guidance on you that you have to have a broad provision. So the SG,
right.
It has to be broad. And the government wants the broadest possible to capture all the entities that have the authority to assist us in trafficking. That's where we're coming from. So
all right, DPM, let's look at those that you have in mind already, and then what would be similar types of entities in other jurisdictions.
And they include agents with investigative prosecution powers in relation to firearms and other criminal activities involving transnational crime, as well as some entities. And body like
so you can limit it. You can limit it in respect of those that investigate the same words that you just use: firearm and firearm offenses and transnational crime involving the use of firearms.
I'm going to tell the minister, be careful, because when you begin to pin it down, why you speak of the criminal offense and broaden it to keep them on it, or something like the postal service.
So DPM, remember?
I know the Minister. The postal service in by law is defined as one that investigates matters dealing with money laundering and movement through the postal system. Largely, in fact, money laundering, but they are the most critical agency in helping us to find the firearm dealers. And I can't name those. That's why I get investigating. The primary partner we're dealing with has a funny structure in their organization, just quite different from ours. And it has recognized that. We still do work with local police. It's a small amount of what we do. So work with the NYPD, they're critical to what we do. New York City Police. Now, entity like INL, International Narcotics Liaisons, is a body that works with DA and ATF separately. So we have to have like our agreements allowed with the entity, but we still have sub-agreements with DA.
So the model that has been used here and elsewhere, having regard to the multiplicity of entities that one may have to deal with, is having a central authority which acts as a coordination point. But I don't think we're going to resolve it in the context of this meeting.
Central, we are central, we have centralized. We have a registrar and we have a national police. And we have a little body in Jamaica, but we can operate with it. Registrar, which is there in the law, and the central police. We have a national police force that covers everybody, even when they are functioning to military or local. But this particular jurisdiction is unique that way.
So DPM, I would suggest that we take a look at the current mechanisms that we have for functional cooperation on matters of crime, investigation and prosecution of offenses, and see whether they are inadequate or what else needs to be provided for in respect of what we have. Because you can create problems if you have multiplicity of entities. Ultimately, it's with a view to bringing a successful prosecution at the end of the investigative process.
They find out the prosecution, but we have a multitude of agencies, and it's a big value right now. They know we can reduce them. They will operate, and that's unique to that jurisdiction. And we have to maintain that. There can be no compromise there where we into big problems. So it's how you get them in there. And
like I say, I don't believe that.
If I write something out, if I leave it out, I run the problem with it out. If I write it correctly. So I'm seeking advice on that. But the policy has said is to include as broad a network as possible because of the problem and how widespread it is. You also, the other district shall have different regulations in its own jurisdiction. Instead of buying firearms in a Midwestern state, nobody takes a record out of him in that particular state. He doesn't walk in and buy guns. When I'm shipping it out of the coastline state, there are different regulations, with a different body you deal with.
So the issue is not providing for cooperation between entities and the registrar, if that is the entity designated for it. It's really how it is provided for. I don't think we will be able to solve the rewording of it in this meeting.
I appreciate what I was saying.
We'll go back.
In terms of policy, I need the technical team to appreciate that. I need the broadest possible structure in dealing with, because the jurisdiction that is primary concern is big. It has multiplicity of jurisdiction in relation to firearms as well, and a multiplicity of agencies.
So
the regulations governing the procurement of firearms in one state is quite different from another, and therefore, exchanging information is tricky dealing with them.
So DPM, because it is premised on some cooperation being entered into between those entities and the registrar, it's not everyone who says, I am dealing with it, that you need to enter into. It will give you a level of flexibility as to who you enter into, but bear in mind that when you have a provision, someone can come knocking on your door to say that, or can go knocking on the door of the registrar, knowing how international cooperation work, and especially in matters like these. And if there is reluctance or any depending on how the response is made, it may be interpreted in a particular way.
No,
so
but we don't have to sign an MOU with them. Everybody come knocking, we don't have to sign an MOU with them. Sign an MOU with them. We have a challenge.
I do believe that the concerns raised can be addressed. The team will have to look back at it.
I'm just it, but I say I will look at it very carefully because I cannot exclude any of the relevant agencies, and bear in mind it still comes under the operationalizing. It means creating a contract or MOU, and not everybody come knocking on my door going to get the MOU or a contract. It has to be people deliberately, decidedly beneficial to the investigation into firearms trading and that. So there's a second link or a second hurdle that can protect the individual, the Jamaican citizen, and must have the freedom to find the criminals who are trading in any area once they are part of an investigative team. So that is by broad. That's the policy guideline.
All right, we look at the entire section of how it is provided for, and take a look back at it. I think that's the highest we can go at this stage, hearing what you said at this point.
What you can look at, I think there for final account that the condition on which you establish the MOUs and contracts, or if you take a contract, MOU and cooperation, can be defined thoroughly. But I don't think we can narrow down the bodies. I don't know enough about the system team narrow down the bodies. There are too many of them involved already. As the criminals change the method, somebody will show. That is relevant to them doing. They have some reasonable successes. They have broadened their network, I would say, significantly. I think in the last 3 months, I've seen the kind of progress that they do for many years. Because all manner of people have turned up, which I didn't know we were involved in investigating criminal transnational crime from them. So I'm thinking it's not 19 bodies, about 20 there, and they all from said suddenly postal service become this one getting into an INL Brown in the school. They have a all huge amount of people. They might want to send the Secret Service here. The Secret Service has special interest, not CIA or Secret Service who protect the presidency. Is responsible for money, fake money laundering. That's the way. So they all have different bodies. The cooperation must be alone with all of them. Now, who you make the agreement with must have some indicating that they do have some responsibility in the area, but I cannot eliminate anybody in the definition of law enforcement. And I don't say it can be eliminated by vacuum, except by what we have here. But in setting up the agreements and in defining the activities, there's much room to ensure that is very focused on what we want, without eliminating the other things. And I need to look at the technical teams look at it. And let's see go. I can't be a narrow policy guideline minister. That's all I can tell you. I can't.
Well, I would say don't conclude on the matter yet, DPM, as to what you can and cannot do. Let's just focus on what you're seeking to achieve and the way in which it is to be done legislatively. That's all I would say.
The lawyers to look at it and tell me what I'm trying to say, that my policy guideline is very broad in relation to the institutions and entities. When you get to the actual agreements and the offenses, and I'm feeling well because I said, not even 3 months, about the last 6 weeks, but we had about 6 interdictions a couple weeks ago, and about 24 coming in. They're rolling in those since they've brought the scope to involve all these individual groups. On the face value, I never thought we were law enforcement agencies, but they have law enforcement roles in their jurisdiction, and they have no coming and cooperating. Everything is working. So I can do nothing to compromise that. So you understand? Yes. Minister. All right.
You're saying a lot of things, DPM, and I don't think, I think you're saying a whole lot of things. What is clear is that you want a provision that would enable you to, as appropriate and as relevant, to enter into agreements for the sharing of information that would, for the investigation and prosecution of firearm offenses and prohibited weapons. All right, so.
Minister, thank you. Next step. So anything else, any other sections for raising SG, CPC, SG and members? With that, Mr. Jackson? Yeah. You want to put it up?
On.
Want to put something on? More? Hand is up.
Oh, sorry. That was from earlier.
I thought you're looking at exemption, but put more.
Not really. We are part of the bigger picture, even without being a parish.
All right. Something. If there's nothing other article to comment on, we have to give the team time to give the instructions, get the CPC's input. I said next week, Wednesday is not too early for the team to tidy up CPC, and they're working hard. But I said I've captured some space, both some of my ministers in other directions, and told the parliamentary team to tell everybody that this law takes precedence at all times. I don't want to waste the time. Too early for.
It's too early for us. But we're engaged in some other things.
What?
Your priority.
Yeah, well, this priority is number one right now. This law must be ready still before the House goes into session. So anything else doing takes secondary role.
Still working towards it. We can't say happen before it. So give us until the week after.
Just remember that there is another bill that is intended to come into effect with this one too, DPM. So
not space has to be operationalized and cannot delay it into next session. So yourself and CPC, I'm asking in next week, Wednesday, too early a date, or do I get back to Mr.
Super. I can tell you from our side, but the other Wednesday will be good.
That's your position, Mr. Richards.
The position of the technical team from MNS and JCF.
JCF. And JCF.
So we'll work towards before
JCF, Miss.
Yes, I'm here.
Right here, JCF. That the common up where that you can all get your information to Miss Grant in time to finish the rewrites by Wednesday.
By the
13th.
By the 20th. So we'll get to her by the 18th.
All right. Ms. McCarthy. Anila.
Yes, sir.
The team is advised that they must give back Wednesday to Mr. Vaz. So please inform him.
Okay, sir.
So the
next meeting.
Fine.
Okay, sir.
Ms. Grant, team advised that they'll get everything to you. Enough time to complete whatever correction you wish to make by the 19th of month. So we meet on the 19th and on the 20th. What can we do on the 20th? Process. 19th.
Just to go back.
See you. You tell me on.
So we would have, if I may, Minister, so we would have gone through, there were just a few provisions.
Yes,
that we want to instruct the CPC on either recrafting or rewording or just tightening up.
And the issue of definition of prosecuting authorities.
As well as the reverse burden.
Right.
Right. So the teams from our side will go through, try and finalize that during next week, so they'll be ready for the 19th to have a discussion.
And the control delivery also. So I would need the instructions before
Yeah, before the 19th.
Before the 19th.
Right.
Yes, they have to give them time. So you can do that next week and give it to Ms. Vance so she can get it to us. So 19 with them. I'm trying to see when we have a final meeting. I'm learning this law. Like every time I talk, I hear another meeting of some sort. Final meeting, I'll be on the 19th. You have to draft, I don't know. I'm a politician, you know. My Minister of Legal Affairs is a lawyer, but she's a politician in this forum as well. Right?
What happened to your voice, DPM?
I had a flu and I got a sore throat after I took the treatment. That's why Mr. Minister was reading for me. That's not what treatment I had. Talked too much this morning in traffic meeting. Traffic people are getting me far more trouble than Firearm Black Minister.
Oh dear. Well, please take care so that you can be restored to full vocal health.
I've got with my little home remedies that work very well after this.
Minister Chairman, you're not authorized to treat yourself.
No, I got the advice and don't tell it from who.
More concern, no.
You might be a little bit jealous. I'm going to tell you which day to bring it. So I'm trying to see when I can say we have a final meeting. I say, no, we have 2 meetings, 19 and 20.
But they say we want to save it for the 26th.
Oh, we keep the 19 and 20, all right? Anila?
Yes, Chair.
On the 19th, we can meet at 10. It shouldn't be a long meeting. Why do we have to meet on the 20th?
Okay, sir.
I'm trying to vote.
Minister, I won't be available for the 19th.
Oh, Minister, I have been a faithful servant of the call.
If it's 2 o'clock in the afternoon, 2 o'clock is better. I'll join the meeting at 2.
19th, we should have everything. SG, you'll have time to comment on both the points you have raised, and we can settle it.
BPM, our comments on reverse burden were sent, but they would need to
discuss with you.
Right.
So the 19th when we meet, we'll be just looking at those things that we are seeking to correct. What we'll be doing on the 20th. You know, the report will acceptance. The way the CPs have been sending the.
So the report would now go back to, so Mr. Party is the one who's working on the report. For the CPC's draft to be attached.
There should be a day for that. Not many things, they give it to you. Tuesday morning, they can give it back to us Wednesday evening.
Sir, I would have to start working on it before that, sir.
I know, you had to figure, that's what I'm saying, that a few pieces that they finished up on Wednesday evening.
I will try my best, sir.
All right, I'm going to try my best for Claudia. You're wonderful soul, but all right. So we'll have to meet in the morning. So, sorry you can't do it in the morning. I don't think you should meet, but although I've been there booked out, you shouldn't be more than 2 hours that morning. Wednesday morning, Tuesday morning. And then so I did have some time Tuesday to Wednesday evening to give service.
Sir, sorry, DPM, just to confirm, both meetings will be virtual?
Good.
Yes, sir. Okay.
Objections. Team members.
DPM, this is Marlene Aldred. Just to clarify, when would the committee be looking at the actual report? Because the focus has been on the amendments, but the report has to match the amendments, or the amendment should match the report. So there also has to be careful study by the committee of the report.
Yes. So when we get the report on.
So that would be the Wednesday meeting.
You didn't have time for it. You probably do that in person. Then.
I'd prefer hybrid or virtual, DPM, please.
So yeah, because it has to be enough. I don't want the errors here. I said, yes, you know, my first I take responsibility for those things. I come to you. I don't want to take responsibility. I know my team has worked hard and been very supportive. But what you're suggesting, you need more time than Wednesday evening to go through it?
No, well, I'm not the one doing the report. I'm just reminding the committee that it actually has to go through the report. And we have been focusing on the amendments.
Does it go through, not just on the amendments? I mean, right? Right. Okay. So to be good, I read clear and loud and practice my phonetics so that I can speak fast, clearly, easily. SG. All right.
I mean, signing off on the minutes, but I noticed that the committee hadn't signed off on some of the minutes, which is not right. You
mean I need the whole day Wednesday?
So that's just pointing it out.
No, I appreciate it. I mean, I want all the difficulties point out so I can still try and work. I get late. But I'm when I have to comp on something that I was expecting. 20th. If I'm home, because I'm actually listening. Mr. Clark, this customs act. All right, we'll work with those 2 dates by SG. What time? If I have to bone somebody before the 26th, I just have to do it. The government's priority. And we really have to carry through. So if I have to go to Thursday, Friday, one of those dates, Thursday, we have to take it. There are 2 committees on Thursday. Teaching council, both bills are going to go to this in the next session. So it will do no harm asking to yield to the firearms to get it in time for the next. Ms. McCarthy. All right. I thank everyone, including my Minister Rita today. My team. Mr. Ford, you're in the center of the world. They're going to the bigger city.
We'll speak to you, DPM. I'm likely to be unavailable on the 19th. If we're doing it virtually in the AM, I should be available at least for part of the session.
Virtually, hybrid at least.
Yes, very well.
Thank you. Team members, Jackson, coming near the end, Mr. Senator Goulding and Senator Scott Motley. We hear a lot from them today, because we know you have been there with us. Thank you all. Have a good evening.
Good afternoon.